Hello, everyone. This is Todd Edwards with ACCG, and welcome to today's webinar on telecommunications law in Pratt, Georgia. A couple of rules I want to set out before we start today's webinar. During the process, you'll see a queue on your screen whereby you can ask questions. We'll be able to see those. Others in the participating in the webinar will not. A few favors: if you could please wait nearer the end before you answer questions or ask questions, because we may actually go over some of the material. And then also, we're going to wait till the end before we answer questions just to make sure that we get through all the slides. You are all on mute, so the others on the call or we here at ACCG, we're not going to be able to hear you. Again, to communicate, go through the questions box. Feel free to follow up with any questions or to get any materials after today's meeting, either by phone or email. Again, I'm Todd Edwards here at ACCG. And then I also wanted to point out that tomorrow morning we're going to post both this webinar and the slideshow presentation on ACCG's website. So it takes about a day to get it up, but by tomorrow morning we're going to have all that posted on ACCG's website. Today we have a very exciting presentation for you, all of which you're, I'm sure, familiar with. I certainly am over my past 10 years at ACCG, dealing with telecommunications, in particular siting issues for both the towers, the facilities, and co-locations on those facilities. We have Joseph Atkins, attorney formerly with Cobb County. We have David Kirk, an attorney with Troutman Sanders, and then myself. A little bit of background on each of us. Joe's a solo practitioner in areas of local government law, general practice, and litigation. As I mentioned, he's a former deputy county attorney with Cobb County. Joe and I have worked for many, many years on this subject. He did a great job, and now he's out again as a solo practitioner. And I'm proud to say that he's got both of his degrees from the University of Georgia. David and I, David again is partnered with Troutman Sanders. We've been working together for many years. He's a counsel to telecommunications companies, and both them and local governments. He's formerly a planner with the Atlanta Regional Commission, did some land use and transportation over there. Went to the University of Michigan Law School and is a fellow at the American Institute of Certified Planners. Then, of course, there's myself. I've been with ACCG for about 11 years, do both the Natural Resources Committee and General County Government. Went to undergrad at the University of New Mexico and grad school at the University of Georgia. The goals for today's session are the basics of wireless communication. We're going to provide some description of site selection processes. We're going to provide an overview of the current regulatory framework, both at the federal level and at the state. And we're going to look at recent court decisions and lessons from case law. And we're going to provide some practice tips for county governments, both from Joe's perspective, mine at ACCG, and David's as well. Most of the laws and rules that we'll be going over actually did emanate from the federal government, from the Telecommunications Act and the FCC. You'll remember a couple of larger proposals that we've dealt with in Georgia in the past 7 years. We'll go over those as well. And several provisions that were considered in Georgia actually didn't pass here, but were later adopted by the FCC. And that was one of the main reasons that we wanted to have this conference call or this webinar today, to bring you up to date with recent rulings by the FCC. Again, I've worked with David and Joe for many years. Sometimes we're on different sides of the issues, but we've always gotten along. We've been very professional, and we will continue to be so today, and I look forward to a very interesting webinar. Caveats: no, we're not here to provide any legal advice, simply an overview of wireless basics, an overview of the legislation, regulations, case law, and legal requirements, and provide some general practice advice, not legal opinion. With that, I'm going to turn it over to David Kirk to begin the presentation.
Thank you, Todd, and good morning. It's nice to be here with my friends Joe and Todd here at ACCG, and to be on the line with the rest of you. I was looking over the registration list, and I know many of you that are on the call and have worked with you from time to time over the years. What we'd like to do is give just sort of an overview of some wireless basics. Just for many of you, this will be a refresher, and then talk about some recent trends in the industry, and then we'll get into the legal end of things. As you all probably know, there are really three basic elements of a wireless network. There's the cell site, which are the antennas at an appropriate height, along with the associated ground equipment. There's the base station, which is the ground equipment at a cell site that helps transmit and receive these wireless signals. And then typically in a location, a centralized location, there's a switch through which all calls or data in a given area go through to a landline or to another mobile device. And here is really a sketch that was done by PCIA, which is the Wireless Infrastructure Association, of how a cell system works. I know there's probably some misconception that the towers actually communicate with each other, but it really is reliant on landline. So you see the folks talking on their cell phones. That signal is transmitted and received to an antenna that's on a tower. That is switched through goes to a base station and then through a switch, and it can either go to the other person on the cell phone or to the regular phone, which that PSTN stands for Publicly Switched Telephone Network, also known as plain old telephone service. So that's an important element of the wireless design. Is typically you have to have a landline in order to serve the wireless. Occasionally you'll have what the industry calls a microwave hop, where that signal will be transmitted to another tower via microwave and then through the landline into the switch. But more often than not, this is the design. There are three basic tower types that I'm just going to give you some very quick overview of those: the monopole, the self-supporting tower, or the guide tower. You're all familiar with the monopole, the self-supporting or lattice tower. Monopoles typically will be effective up to about 200 feet. After that, as far as the design and it's not as efficient. The self-supporting or lattice towers can go upwards of 200, close to 300 feet. And then the final tower, which we don't see as many of as we did in the old days of wireless technology, which means 10 or 15 years ago, the guide tower. And these can be very high. Typically, a television transmittal tower would be a guide tower, such as the WSB tower that you have in downtown Atlanta next to the Freedom Parkway. Those are the basic types of towers, but what we've seen a lot more in recent years is what we call stealth design, which is designing towers or antennas so that they blend as much as possible into the surrounding landscape or the built environment. And you can do this both in an urban setting and in a more natural setting. There's a wide variety of ways to do this. The important thing to keep in mind is that with stealth design, there's often a trade-off in terms of the design going toward one of these designs and the ability to be at a certain height or to co-locate antennas on a facility. I know a lot of local governments have a preference, as does the wireless industry, quite frankly, of co-locating on existing towers, and employing stealth design sometimes restricts the ability of the carriers to do that. So let's go through some very quickly. This is an ancient stealth treatment that you see. This has been around for a long time. This is what we call a monopine, designed to look like a pine tree. These can be very effective in a natural environment. A slick stick, in which the antennas are internal to the tower, and in terms of efficiency, this is not typically the most efficient utilization of the space, because instead of the antennas being next to each other at the same elevation, they have to be sort of stacked in a sort of like a barber pole design inside the tower. So this typically limits the ability to co-locate, and it also the industry has found that there's some issues with maintenance on antennas because of heat buildup within the antennas themselves, within the structure. You can modify that slick stick to have a flagpole on it. This has been used in some places. This is a lot shorter design where there's the cell is at the top of a light standard, and then you can also mount them on buildings. This is actually a photo simulation of one that my law firm recently handled, and the little penthouse at the top is actually where the antennas are located on the roof, and the material that's on the outside is essentially a digital image of the side of the building, so that you can really screen those and mount them on buildings, even in historic areas, which this was in a historic town in Georgia, historic downtown, where you can very effectively screen those, and so they blend in quite well. We're not quite to this point yet, but who knows? Maybe someday we will get that. We'll get to that point. I actually have seen one stealth tower that was designed to look like a giant pencil that was across the street from a historic pencil factory, I think somewhere in Pennsylvania. But I decided I was not able to find that slide for today's presentation. Let's talk a little bit about sort of the status of the wireless industry and trends, because I think it's extraordinarily important for local government officials and planners at the local government level to understand sort of where things have come in the industry, what's going on in the industry, because that drives a lot of the demand for new service in your community. Right now, close to 45% of Georgia households rely entirely on wireless communication. That's for their personal, their business, their emergency communication. That's not my number. That's a number that collected through the National Center for Health Statistics, which is affiliated with the CDC here in Atlanta. That's a very recent number. I think that that number reflects the status of things as of the end of 2014. About 70% of all E911 calls are made from a mobile device, and many of these, a significant number, more than 50%, are made from residences. So, what this tells me is over the course of really the last decade or so, wireless service has gone from being seen in many ways as a luxury to a necessity, and quite literally for many people it can be a lifeline, because if you have half the households in Georgia relying entirely on a mobile device, and that means they do not have a home phone, and you have a situation at home where you need to summon emergency services for a health or public safety issue, that can quite literally be your lifeline to seek help. So that is one of the what I find very interesting trends, and here is really very striking. This is again from that CDC survey. You see 44%. This is a national number. Just in the past 11 years, we've gone from single digits of households with wireless service, including children with wireless service, where you have now about 45% that rely entirely on wireless service, and then children from households, almost 55% of children in the nation live in households that are wireless only. So let's talk a little bit about Coverage and capacity. Coverage is sort of the basic service that was provided 10 years ago. That was really the focus of the industry when I started working with local governments and with the wireless industry about 15 years ago, was just providing basic coverage to communities. And that was focused almost entirely on voice coverage, using a cell phone. And as really the wireless systems, the wireless devices have evolved so much. I think one manufacturer comes up with a new phone every 6 months to a year. I think we're now at 6s and 6S's in that particular one. And it seems like just yesterday we were buying 4s and 5s within just the last couple of years. And these devices are designed not just to transmit voice. The voice is really just an app on this wireless device. They're designed to transmit data. And it's not just downloading YouTube videos. It's work applications, it's documents for work, those sorts of things that are really driving a lot of the evolution in devices, and consequently evolution in the wireless system that serve those devices. So as those devices have evolved and as the scope of use has increased, the carriers are really challenged to provide enough capacity in the system to meet the need. And so the majority of the new wireless infrastructure is aimed at increasing the capacity of the system, increasing the speed of the system in delivering data and providing that to the customer. We see ads on television all the time about slow downloads and so forth, and that's really what the customer is expecting. Is when you want to get information on your device, I won't call it a cell phone because it's really a handheld wireless computer, you want to get it quickly, and you don't want to have your phone buffering or your device buffering. You don't want to lose a connection. Unfortunately, most local government ordinances are still based on this paradigm of coverage. And so there's a challenge, I think, for local governments to take into account not just the explosive growth in wireless usage, but the change from solely a capacity-driven industry to one that is still capacity in some, or still coverage in some places. Excuse me, coverage-driven industry to one that is both coverage and capacity. Okay. You remember the statistic I gave you about wireless-only households, and the number of calls, of U911 calls, and the usage, quite frankly, of people using them in residential areas, and that is an increasing challenge, both I think to local governments and to the wireless industry, is serving residential areas. You have a lot of people working from home, not just employed at home, but people who work in an office who also will want to work from home using wireless. And so there's a challenge to serve residential areas. Most jurisdictions' ordinances severely restrict the placement of wireless facilities in residential areas, and that's a big challenge, and I think a big point of friction going forward. Some other things that are going on in the wireless industry is using small cells and what we call distributed antenna systems, or DAS, where they're warranted and feasible. And by that I mean there are a lot of DAS systems deployed in places like, and Todd and Joe will like this, the University of Georgia.
There we go.
The University of Georgia Stadium, Sanford Stadium. So all those dogs, when they're whooping on Saturday, can contact their friends and let them know where they are, and keep in touch with friends and family who are at the game and after the game. but that's a place where you have an incredible concentration of users. And there is some application for small cells in very concentrated urban areas. Again, there's still challenges to that, but the systems are evolving. And then I know when I started doing this work, there was a lot of talk about speculative towers, and quite frankly, there were a number of speculative towers placed in the earlier part of my career back in the around 2000. Increasingly, that's not the case anymore. The carriers are going more toward third-party tower companies that are doing build-to-suit tower deployment, and I think that's also something that local governments should be aware of in terms of that trend. So, just to summarize what the wireless industry is trying to do to respond to this incredible growth in need and in the desire for speed and capacity is upgrading existing sites, changing out antennas, adding the antennas that are more suited toward faster data transmittal. They're adding capacity whenever it's possible. They're doing this primarily through co-location on existing towers or other structures. That is clearly the easiest, the fastest, the most economical way to meet the need. That's the preference of the industry. I think that's the preference of local government, to use an existing tower where it makes sense, both from the industry standpoint in terms of being located in a place where it can address the need, and only adding new towers really if necessary. And there still is a need for new towers. There are parts of the state where coverage is still an issue, but increasing coverage and capacity through new tower deployment is something that the industry continues to do, despite its efforts to utilize existing facilities and other structures wherever possible. I think now we're going to move into the federal regulatory framework, and I'm going to hand things over to my good friend Joe Atkins to lead this discussion.
Thank you, David. And just briefly before we run through the slide, I do want to thank David and Todd for helping put this, particularly David, putting this PowerPoint together. So where do we begin? We begin when we're talking about the regulation of tower sites. The best place to begin is the Federal Telecommunications Act. It is essentially declared in that act that it was the policy of Congress that we would have a timely or rapid deployment of wireless infrastructure. It's a federal priority. Everyone needs to remember that. This is not your average zoning case. When you have a cell tower case, we're dealing with things that have been established as the priorities of the United States. And within that act, as you see on the slide, there should be no unreasonable discrimination. There can be, you can't do anything that would prohibit or have the effect of prohibiting wireless service. You have to act within a reasonable amount of time. We'll get into a lot more detail in a little bit about that. And also, the denial that a local government does must be in writing and supported by substantial evidence. Again, more details in a little bit. One thing that is absolutely clear, and I cannot emphasize this enough, is that you cannot consider the environmental effects, the health effects of radio frequency emissions with these towers. Do not do that. I strongly suggest that you put in all of your opinions that you did not do that, because you will have your decision reversed if you do. And then if there is a problem, if you deny a tower and you go to court, there's supposed to be expedited review by the courts. Now, sometimes that occurs, sometimes it doesn't, but that is what the statute requires. Obviously, there is an elephant in this room. More about that in a moment. But Section 704 of the TCA, the Telecommunications Act, does place limits on local governments, and except as provided in the Act, nothing shall limit or affect the authority of state or local governments. Remember, in some jurisdictions, the states actually handle this, but in Georgia, it's the cities and the counties with respect to their decision over the placement of these. Now, there are limitations on that. So if you step back and you say the general policy is local governments, you have your land use authority just like you do in other cases. But there are special limitations, and those limitations are that you cannot unreasonably discriminate among providers of functionally equivalent services, and what you do shall not have the effect of prohibiting and shall not prohibit the provision of wireless services. You also must act within a reasonable amount of time. Again, we'll give you some specific time frames in a moment, but the legislation, the federal statute itself, does require action within a reasonable amount of time. Now, any decision that you make to deny a request to place one of these towers or facilities in place has to be supported in writing by substantial evidence containing a written record. Again, we'll have more details about that in a moment, but I strongly recommend that my local government clients write a decision when they choose to deny one of these facilities, because it makes it a whole lot easier for the courts to figure out what they did. And candidly, it's just easier to work from something that's in writing as opposed to having to glean a bunch of things from different places in the record. Again, as mentioned earlier, no state or local government may regulate wireless facilities based on the environmental effects of radio frequency emissions. And I can tell you that nearly every hearing that we would have with these, you would almost always have someone stand up and say, we don't need this because we're worried about the health effects of these radio frequency emissions. Probably the best way to handle that if you're a local government is to simply explain, sir, we hear what you're saying, but you need to understand that Congress has legislated in this area, and we are not allowed to consider that. And most of the time, people seem to understand that. Sometimes they don't, but you cannot consider that.
If I can just interject on that last point, there is, in a number of jurisdictions, there's a requirement that there be some certification that the antennas that are used or will be used will comply with the FCC regulations. I think to some extent that's kind of a moot point, because under the licenses that the federal government issues to the carriers, they are required to meet the FCC's regulations in terms of radio frequency emissions, and the manufacturers, importantly, are required to meet those regulations. So I think that's, I would caution local governments of spending too much time trying to verify that sort of thing, because quite frankly, the carriers and the manufacturers would be at significant risk if they didn't operate in that manner. But there is an ability of local governments to get some sort of certification from the applicant that they will meet all FCC regulations concerning emissions.
And picking up on what David said, in my experience, which is mostly in Cobb County, in my experience, that is usually something that our carriers that we've seen go ahead and provide to us. We don't even have to ask for it. But I agree, it's definitely something that you would want to have your staff double check and just make sure it's there. I've never had it not be there, but again, I guess theoretically that would be possible. Now, if, let's say you have one of these cases, and let's say that you decide for whatever reason, if you're a local government, to deny the application and not allow the tower to be built. The provisions of the law of the TCA provide that any person adversely affected by a final action of the state or local government in this area may, within 30 days, commence an action in any court of competent jurisdiction. Every one of these cases I've had has always been in federal court, and I think, David, that's been your experience too.
I had one case where some property owners in the jurisdiction filed a complaint in Superior Court in the county, but that was removed to federal court almost immediately.
And I did have one case recently. I'm not handling it now because I left the office, but it was kind of like that. It was a property owner who filed a case where a tower had been permitted, and the neighbor was displeased, and the neighbor filed a suit in Superior Court, but I believe it was also removed as well.
Yeah, because it's really a question of federal law, and the federal district court, whether it be the Northern District or Southern District of Georgia, would be the appropriate venue for those sorts of actions.
And then the court is required under the statute to hear these cases and render a decision on an expedited basis. Now, I know there's a recent case that I think David was involved in where that did happen, and that is the way it's supposed to happen. For better or worse, in my experience, the U.S. District Courts don't always do this on an expedited basis. I don't really know why. A quick anecdote, I know at the local zoning level, when we had a new Superior Court judge one time, I found that 9 of my 10 zoning cases in that county were assigned to the new judge. It was a newly created judgeship. I later found out that they didn't assign those randomly, that all the other judges could get rid of the cases they hated the most, and so they gave them all to this particular judge. He's now been on the bench about 10 years, but at any rate, I can't necessarily analogize with cell tower cases and zoning cases, but if they're like zoning cases, maybe the judges don't like them, and maybe that's why they keep putting them off. Having said all that, this is correct. Your slide is correct that they are supposed to hear these on an expedited basis. And local governments, you need to be prepared for that eventuality. You don't need to do one of these and think, oh, we're going to have all this time, because you may not. There is to be no unreasonable discrimination, and that's sort of a term of art. The intent behind that from the House Conference Report was to provide flexibility to treat facilities that create different visual, aesthetic, or safety concerns differently to the extent permitted under generally applicable zoning requirements, even if those facilities provide functionally equivalent services. So what that really means is discrimination is a dirty word a lot of times, but in these cell tower cases, you do have some discretion to reasonably discriminate as long as you are treating similar uses and similar situations similarly. So, for example, if you look at the next slide, if there are neighborhood preservation concerns, such as residential areas, and more about that in a moment, if there are aesthetic concerns, those things can be taken into account. You saw the slide earlier that David showed with the I guess I'll call it a tower. It really wasn't a tower, but it was on top of a historic building. They could do that there because it was appropriate. It was appropriate from a zoning standpoint. I always mention that in front of David because David does have a planning and zoning background. That would be considered, I think, good planning and zoning. Correct, David?
Yeah. Well, you can require in historic areas that facilities be screened for aesthetic purposes. As I mentioned, that slide that I showed of the penthouse installation, I guess, on top of the historic building was a requirement of that community that it would have to blend in. You can't say because it's an historic area you can't have service, but you can say because it is an historic area you can treat the aesthetics of a facility differently because of that resource.
And I do recall, and this is a while back now, there was a village or a small town in New England, different federal circuit from us, First Circuit, that actually said there will be no cell towers whatsoever. You may remember that, David, in our town. And obviously you can't do that, but this would be a good compromise position to do something like that, where you still allow the service, but you may treat how you get the service a little bit differently. Now, the no prohibition on services, this is what, in my practice, I've seen this and the substantial evidence in the record cases more, and I have not seen as much of the discrimination as in the discrimination cases. But the no prohibition on services cases, in my experience, tend to be bigger cases. If you were to have an outright ban, as we mentioned a minute ago, on personal wireless service, that's prohibiting service. You simply cannot do that. But then there can be actions that you could take that would have a prohibitory effect. Arguably, you could have a prohibition where you're keeping a provider from filling a gap in its overall system. Now, there's still, I think, a lot of litigation that's going to have to go on in defining what the parameters of that are, but conceivably you could have a situation where perhaps one or two towers closing the gap, not allowing that, would give a cause of action for that. Repeated denials of good faith efforts by providers to use less intrusive alternatives or less sensitive sites. That, coupled with gaps in service, I think could probably lead to a prohibition of service claim and probably a valid prohibition of service claim. Again, more about that later. The decision needing to be in writing. This is a biggie, and some of you may know that the Supreme Court of the United States weighed in on this locally here with the city of Roswell not too long ago. There was a lot, and there still is a lot in my mind, of question about what do you do with the decision in writing. Well, I don't think I would recommend that you just have a letter and you stamp it denied. I think I'd be very careful sending a letter saying merely, as a result of the public hearing, your application was denied. I think we've seen some of that stuff before. I guess theoretically you might possibly get away with that in the right circumstance, but I do not recommend doing that. As most of you, if not all of you know, any vote that you take on this needs to be recorded in the minutes. I was always taught, and I think this is still the law, that when a local government takes action, that if it's not spread across the minutes, it didn't actually take the action, it's not officially binding. But I would recommend that you go beyond any of those things. My practice has been, and we'll get into more of this perhaps at the end, to either write or assist staff in writing if you're going to deny one or severely curtail an application in what they wanted, I like to write a very detailed, lengthy decision, kind of like a court case, because I think it helps the U.S. District Judge figure out what you did. There are some now, because of this Roswell decision, there are some mechanical issues with getting that done in a timely manner, but we'll get to that. But what the Roswell case said was that reasons don't necessarily have to be in the denial notice itself, but they must be stated with clarity in some other written record that is issued essentially contemporaneously with the notice of denial. So technically, you could just do a stamped denial letter as long as you've got a really good record, but that makes me very nervous, and I think that makes it very difficult for the U.S. District Judge to decide the case.
And I agree, and I guess my statement on that is, why do it that way? Why hide the ball? If you're going to deny something, and quite frankly, we hope that you won't, but if you are, then put your reasons in writing and make sure those reasons are valid. I know that there are a number of cases out there where the local government has denied something and then made an effort after the fact, outside of the minutes, outside of the decision to substantiate that decision, and courts have not really looked favorably on that. I think if you look at some of the oral argument associated with this T-Mobile case, and you look at some of the detailed writings in the opinion, I think there's a feeling among many of the justices is, why not just write a letter, say why you denied it, base that denial on evidence that is in the record, and provide that to the applicant. So while you could, as Joe said, have a written notice of denial and separately issue these reasons, why put yourself at risk of running afoul of this decision, and why why act in a manner that is really intended to make it harder for a court to divine what your reasoning may have been.
And I would say that I don't want to get too far off topic here because we can discuss this more later, but let me just mention while it's on my mind, yes, it will be more work on the front end, but I think in the end it will actually cause less work for everybody. And I think it also assists your governing authority, your Board of Commissioners, probably will assist them in making their decision because it will cause them to articulate what they're basing their decision on, which is, I admit, is very different from what they normally do in a normal zoning case.
Right.
Again, the substantial evidence portion of the discussion, the written record, this is really the legal aspect of what you find in the opinions. Substantial evidence is more than a mere scintilla. It means such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. In other words, the court is not free to substitute its judgment for that of yours, of the local government, but the court is required is compelled to review the entire record. And if the court reviews the entire record and really can't understand why you made the decision that you did, or sees that there's overwhelming evidence on the part of the applicant that refutes every reason you've given, you're going to have problems. And so I think it's better, again, as we said a minute ago, to do this on the front end, spell it out, and move forward that way. If there's conflicting evidence in the record, you need to adequately explain why you're rejecting that evidence and why you're favoring other evidence. The local authority decision to deny must be overturned if the court cannot conscientiously find the evidence supporting that decision is substantial when viewed in the light that the record is in its entirety, that the entirety of the record furnishes, including evidence opposed to their view. So, for example, if you have, and I'll give this example, I know David knows very much about this case, if you have someone who is concerned about the height of a tower and the fall zone of the tower, and the applicant came in with engineered drawings and engineered reports that said, look, this tower is designed to break, has a break point, say, 50 feet up in the air, and you're still insisting that the tower can be no taller than 50 feet, you better be prepared to haul an engineer, a PE, in to refute that evidence that was presented by the cell tower company, because federal judges are starting to look at that and they're going to question that. And so you don't need to just, I'll give you an example. We had a case where there was a concern about fire on a cell tower because, and I'll go into more of this later, but somebody had gone on the internet and had seen that there were some 2 or 3 cell tower fires, and therefore that was a reason not to allow this fire. David shaking his head. You know, that's just not going to get it. Maybe at one time you could get away with that kind of stuff, but that's a federal judge is going to see that, and it's going to destroy your credibility. If you may have had some valid reasons to deny that application, but you need to be careful about that. And let me just tell you, and I don't mean this negatively toward any of our U.S. district judges, they talk. They talk to one another. They bounce ideas off of one another, and if they hear that such and such jurisdiction has taken such and such position on this thing, particularly in a cell tower case, think about it, the average federal judge doesn't get a whole lot of these, at least not now, they may be in the future, but I can see Judge A going down the halls and talking to Judge B, or at a cocktail party and say, well, I got this case and here's what they're saying. And then Judge B, oh, well, yeah, they did that in this other case, and let me tell you how outrageous. I mean, you just don't want that talk going on about your local government.
Yeah, I think there's an important point here that opinion is not evidence, and you know, a picture off the internet is not really evidence. You know, I've worked with carriers for more than 15 years, and I recall I actually recently polled them in connection with an application that I was working on about tower failures and how many tower failures we've had in the state of Georgia. And by failures, I don't mean towers breaking and falling apart. I mean having to be replaced because of some sort of structural damage. One was from a fire where a contractor who was trying to install a new facility was using a welding torch, and actually the knucklehead set the coaxial cable on fire. that tower warped a little bit, and that's considered a tower failure. The other, I believe, was a direct hit from a tornado, and that slightly bent the tower. As the industry has evolved, I think the engineering has improved over time, and the engineering is such that towers can be designed to have certain stress points that improve the safety tremendously, and so I think Joe's point is very important, that a judge is going to look at the evidence, and if the applicant submits a engineering report stamped and sealed by a Georgia registered professional engineer, and the decision is made that, well, I just don't believe that, I still think it's not safe, that's probably not going to hold up in court. And in fact, it did not hold up in court.
I want David, I want you to talk about this next slide.
Sure.
Because I think you're very familiar.
Yeah, I mean, this is really the crux of this Columbia County case. My firm was involved on behalf of Verizon Wireless of the East in this case, and there was the record was replete with engineering documentation addressing every aspect of what was required as part of the application. I believe, if I'm not mistaken, I believe the staff recommended approval, and when it got to the governing body, actually when it was introduced, when the item was introduced on the agenda, the commissioner introducing the item introduced it as a motion to deny, and it was difficult for my colleague who was at the hearing to even provide testimony at the final hearing, and this was a decision that I think had been made prior to the hearing. I think that was something that the judge picked up on, and that would be, to me, a caution to what Joe was saying about writing up a decision in advance, because certainly things that come up at the hearing could influence the decision. But here there was record in the engineering reports and conclusions regarding the safety of the tower, the design that demonstrated it was not a hazard to residential properties that were some distance away from the tower, and the only support in the record was a statement. It was really more of an after-the-fact statement that I just don't think it's safe. And again, an opinion does not rise to the level of evidence, and that was really what this case turned on.
Okay, we love this no environmental health effects considerations, because we talk about it a lot, but it's important. Again, I can't emphasize it enough. We've addressed that. Make sure that your applications do certify that they're in compliance with FCC standards and regs, but I think you're going to find that's not going to be an issue. Use of thinly veiled proxies are scrutinized by courts. In other words, be careful how you couch. If you're going to deny one, if you feel like the evidence warrants that, again, I would caution you about going to the internet and saying, well, 3 cell towers in Washington State caught on fire, and therefore we're not going to allow any cell towers anywhere where they can catch on fire. That's the sort of stuff you have to watch out for. And I've been representing local governments. I've been practicing for nearly 30 years. I've been representing local governments for about 25. I've sat there. I understand that you get some citizens who are very concerned, and I don't want to diminish those concerns, but this is kind of where the rubber meets the road. This is where the citizens' concerns kind of have to meet the engineering and the science, and you have to reconcile those two, and that's not an easy thing to do. But be very careful when you get these sort of outlandish claims about, well, this could happen, just watch that. Aesthetics alone really are not something that you can base a denial on. However, I will tell you that aesthetics combined with other things sometimes can be the solid basis for a denial, particularly if you work with property values. Now, you have to be careful about that. The cases that I have been successful in where we have denied a cell tower based on aesthetics and property values is a case where we had appraisers and experienced realtors who had been working in the area for a long time come in with comparables and produce information that supported that position. If you just have somebody that gets up and goes, this is ugly and it's going to make my house worth less, that's not going to get the job done. I will also tell you on the other side, I have had, not David, but I have had attorneys and companies where the applicants come in and produce just a generalized argument that, well, this doesn't adversely affect property values. Look at these expensive homes down the road. Well, we know because we did the zoning, those homes were built after the tower was in place, so there's a difference there. So you just need, if you're going to do property values and use that as a basis, you need to be very careful about how you do it. But done correctly, it can be, and David may disagree with me, but in my experience, it can be a valid reason for a denial, assuming other things are in place. Right. A discussion of the record is very important. I always get nervous when a governing body just hears the case, there's no discussion, and they vote to deny. You don't want that. And it may be that if you're their attorney, you need to get with them or get outside counsel or someone with them who knows this kind of stuff, sit down and educate them, not about how they need to vote on the case, but what they need to be looking for. Yes?
Let me just make a couple points about property values. In my practice, I don't just do telecommunications. I work with industrial and residential and retail clients as well. And a number of the brokers now tell me that when their prospects are looking at a site, one of the first things they do is they get out their wireless device and see what sort of service they have. That goes back to what I was saying at the very beginning about the increasing use of wireless devices for business purposes as well as for personal communication and emergency services. And I admit this is all anecdotal, but I think with the increasing reliance on wireless, I'm not sure the property value argument is going to be as strong going forward, particularly when you have the wireless industry offering up alternatives that might be less intrusive, might be stealth design, might be some other sort of design that would be less intrusive in a particular area. Just another very quick, again, anecdotal point. In preparation for the G8 summit that was held down at Sea Island many years ago, I was asked by my client to assist with the placement of several new telecommunications facilities that were seen as important to the communication services during the G8 summit. And after, we put several on Sea Island and St. Simon's Island, and after the G8 summit, I happened to be there about a year later, and the radio commentator was interviewing the county commission chair and asked what the legacy of the G8 summit was to that area. He said, well, we finally have good cell service on Sea Island. And so that's from a marketing standpoint, when you're trying to attract folks who rely on wireless devices but may live in, may see Sea Island as sort of a second home or a vacation home area. That's another thing that is increasingly coming into play.
Well, and that's correct. And one of the things that I was going to mention, and I'll mention it real quick because I think now's the time to say it. We are seeing, as we have seen in so many areas of the law nationally this year and in previous years, there are tipping points. And this is just a theory of mine, but I think our younger citizens, I'm 54, so I'm not younger anymore, but our younger citizens, I think, use these devices even more, and I think probably there's maybe a little bit less resistance to the infrastructure as citizens and voters get older. It's just something that we'll probably see. When we'll get to the point where they don't care at all, I don't know if we'll ever get to that point. But I do think it certainly affects some of the opposition that we've seen.
Yeah. And if you went back to that chart I showed at the very beginning of the households that are wireless only, and if you go back to that report, they break it out by age group. And I believe if you look at the age group of households under the age of 39, that number is closer to somewhere between 60 and 70% of those households are wireless only. And I know, again, just from my experience at our law firm, I don't think there's any of our younger attorneys that have a home line. It's just folks like us who have been around for a while still rely on a home phone.
Let's move, to the remedies available under TCA. It's actually a lot more important than you may think. First of all, the three remedies that we're available of generally would be a writ of mandamus ordering the local government to issue the zoning approval or the land use permit or whatever it is. The other one would be an injunction ordering issuance of the permits, which would be similar. And then, of course, there's always the option, which you see a lot of times in the zoning context, of a remand, as some of us say, for you to reconsider the case, maybe with some instructions from the court. Remember that the Telecommunications Act puts these federal judges under an expeditious ruling requirement. So I wouldn't count on the remand. I really wouldn't. I think you need to understand that if you deny one of these and you really do a poor job of denying it, you may just have a judge saying you're going to have this tower. Now, that's one thing if it's one tower. It's another thing if it's a prohibition of service claim where they're looking at your entire, I don't want to use the word scheme, your entire ordinance system that you're using to decide these. If you were to get into a situation where your ordinance was really a mess and there were a prohibition of service claim and you were found to be prohibiting service generally, you might find yourself in the same situation that some local communities have in the past where their zoning ordinance is declared unconstitutional. And you know what that means is open season. People come in and file all kinds of stuff. Now, I know David's clients would not do that, but we're smiling. But you do need to be careful about that. This is serious business, and you don't want to thumb your nose at this law, and you don't want to thumb your nose at the court. You want to take it very seriously, be very careful about it, because you may draw back a nub if you try to do that.
All right, back to the elephant. Many of you may be familiar with the old Indian proverb about the blind men encountering the elephant and feeling different parts of it. Person feeling the leg thought it was a tree. The person feeling the tail thought it was a rope. The person feeling the trunk thought it was a snake. That sort of thing. And just to draw on that parable, there have been numerous interpretations of the Telecommunications Act over the years, different provisions, and what we're going to go into now are some federal actions that have sought to clarify different provisions of the TCA. This concept of unreasonable discrimination is one of them, and this seems like ancient history, but it was really only 6 years ago. The FCC, the Federal Communications Commission, issued what they call a declaratory ruling, which was somewhere in the neighborhood of 160 pages long, discussing the Telecommunications Act and some of these various provisions. And one of the provisions they dealt with was this unreasonable discrimination, and they were asked to essentially rule on the question of if, for instance, my client, and we'll say Verizon Wireless, comes into the community and is seeking to provide service there, an AT&T or Sprint or some other carrier had what was deemed to be adequate service there, the local government could not deny Verizon's application on the basis that other service was provided, that they had adequate service in jurisdiction using another carrier, so we don't need Verizon, we've got AT&T, or vice versa. And the FCC made very clear that doing so is unreasonable discrimination. that same declaratory ruling is probably better known for the limits it set on reasonable time, the so-called shot clock that it put in place for local review and action on applications for zoning approval for telecommunications facilities. And then in this case, the FCC said from the time the application is submitted, provided it's complete, you have a 90-day period to approve co-location and a 150-day period for a new structure. And you can use that initial 30-day period of that either 90 or 150 days to determine if the application is complete. And by complete, it means does it have everything that your ordinance says it has? Not does it have everything that your ordinance says it has, plus these several other things that we would like to have or we've come up with just to delay the completeness determination. So I think that's an important thing to keep in mind is you have 30 days from the time you get an application in your office to make a determination that it is complete. If it is not complete, you are supposed to provide notice to the applicant in writing of those things that are deficient, and then the clock essentially stops until such time as those things are provided to you. Not surprisingly, this declaratory ruling was challenged in a case that went all the way to the Supreme Court, the City of Arlington, Texas versus the FCC. And essentially what the local governments were claiming is the FCC had no authority to determine what these somewhat ambiguous terms were and what they meant in the Telecommunications Act. And the Supreme Court disagreed, and I think rightly so, that a federal agency does have the authority to interpret ambiguous terms in legislation concerning its purview, concerning things that it has regulatory authority over. So the shot clock and that one provider rule are now essentially the law, and make sure that you keep that in mind when you're crafting your ordinances and reviewing applications. While this FCC case was actually going on, is still going on in 2012, another law was passed by Congress. It's actually part of what they call the Middle Class Tax Relief and Job Creation Act of 2012. It's now, this particular section is now called the Spectrum Act. And essentially what this said, and this again caused sort of an elephant moment about saying that the local government may not deny and shall approve an eligible facilities request for a modification of existing wireless facility that does not substantially change the physical dimensions of such tower or base station. So what the heck does that mean? Well, it took a couple of years, but the FCC just became finalized. It was issued first in 2014. That's why the slide says 2014 FCC report. It's actually published in the Federal Register in January of this year and is now law. But it provides, it first adopts some exclusions from environmental and historic review for certain co-locations. But more importantly, for purposes of this discussion, it provides guidance on the implementation of the Spectrum Act. Importantly, it tells you what a substantial change is. And here is essentially the laundry list of what the FCC has defined as substantial change. If you have a tower and you're increasing it in height in order to co-locate more facilities on it, if you're increasing in height by more than 10% or 20 feet, whichever is greater. If you're greater than that, that's a substantial change. So if you had a 150-foot tower and you wanted to increase it by 15 feet, that would be 10%. That is not a substantial change. If you want to increase it to 170 feet, that is still not a substantial change because it's the greater of those two. If you extend outward by more than 20 feet from the existing tower, and that's existing tower and all of the existing appurtenances, I think is the term that is used, then that is a substantial change. If you're installing more than 4 cabinets at the base station, that is considered a substantial change. If you're excavating outside the current lease area, and I've underlined that because I think that's an important point. If you're excavating outside the current lease area, that is a substantial change. A lot of times, and I actually had some of these recently in Cobb County, where we were excavating, we were expanding the tower compound, but we're not expanding the tower compound outside of the lease area. And so therefore, it fell into the category of those types of modifications that the local government shall not deny and shall approve, may not deny and shall approve. If you're have a, I sort of noodled on what this next one was, if it defeats the existing facility concealment elements. And I think if you go back to that historic preservation picture I saw, and you've got the antenna on top that's nicely camouflaged, and then you want to put a monopole on top of that, I think that would defeat the existing concealment elements, and that need not be approved.
Yeah, when I saw this one, I have a feeling that at some point there may be some more litigation or further refinement of the rule on that. I mean, don't you think, David? Because I can see how there could be some questions.
Well, it's interesting. When this first came, when this was being talked about, there were some folks who make their living consulting with local governments that were presenting those sorts of parade of horribles about, here's what the industry can do under this. They can put a self-support tower on top of a monopole or on top of an historic building, and I don't think that falls within the protections that are offered by this order. But that still it wouldn't surprise me if there was perhaps more litigation on this.
Somewhat in that regard, I had a question. This is Todd again. If you had a 150-foot tower, your first expansion fit within the definition, raised it by 10 feet, could you incrementally keep increasing it so long as each time it didn't change the definition or didn't fall under substantially changing the size? That's one of the concerns I hear most from local.
Yeah, and I don't recall if that's addressed directly in the FCC order. Do you, Joe?
I don't, and that's why I mentioned I have a feeling there may be further battles over that.
Well, I mean, let's be honest and just play devil's advocate. It says right here, doesn't defeat the existing facility concealment element. If you're advising a local government, couldn't you put that in the original approval of the application?
Well, if you look at the last one, I think that's where the FCC says, no, you can't say this will never be more than X number of feet tall because that contradicts the substantial change.
Well, and I do think that may be where we may see some battles at some point, because I know in my experience that we almost always approve it to a certain height, but we not only do that, we approve all sorts of other things, and it's usually by agreement on the carrier's part too, right, to do various things to soften it. I know you've got some things about camouflaging and concealing. I think that's where maybe the battleground's going.
Perhaps, yeah.
And the other thing, and I don't think we mentioned it, and at what point or what height does it require under FAA, the lighting and other?
About 200 feet.
Yeah. So, I mean, the biggest concern is if you get something that's 160, 180, you get an addition to it. Now all of a sudden it goes above 200 feet, and you've got lights in an area that could be quite contentious. But does the FCC say anything about that?
I don't think it's anything directly about that in the order, but I think from a regulatory standpoint, that brings in the need for additional FAA would bring in FAA determinations, that sort of thing. I think the issue that we're looking at here is, do we allow an existing tower to be increased by some increment, or by denying that, do we create the need for a brand new tower?
Sure.
In close proximity.
Yeah.
So I mean, I think that's where the tension is that Joe's referring to, that you know, may cause some.
Well, and probably, and we're speaking generally now, probably on that particular issue, and David, you can address this better than I can. I suspect that at some height, that tower would not be designed to go any higher from a load standpoint anyway. So
potentially, yeah.
And I don't know that. I mean, maybe they're building these things. You could add another 50 feet and it could still hold it up, but I don't know. So it might be a self-limiting thing.
I mean, and I'll be honest, this has always been a concern when we looked at the legislation here in Georgia on defining it, but as Joe stated, if it's not clear, we may run into litigation.
I think we'll just stay tuned on that one. You know, I think the industry's preference is to locate on existing towers, and I think if we've got a tower that's structurally, I mean, one of the things that we'll get into shortly is some of the Georgia stuff, and maybe we should move through this. We can talk about what a local government can require with regard to tower expansions. So again, this would be an eligible facilities request, provided that distance between, you know, antenna array number 1 and antenna array number 2 is 20 feet or less, or 10% or less of the height of the tower. And you know, SEC is very clear on that is something that the local government must approve. You can still require an application. You can still require some information, but ultimately the SEC has said that it's in the federal interest to approve that. So, as I said, you can require applications asking for information that's reasonably related to determining whether the request meets those requirements. You have a 60-day shot clock on these sorts of things. And again, incompleteness determination has to be in writing, specifically state what those deficiencies are. And if you institute a moratorium while one of these is in process, the time frame, the shot clock continues to run. And that's, I think, consistent with local zoning law, that you can't stop the process in the middle and say, let's go change it.
Yeah, similar to the vested rights.
And as Joe mentioned earlier, if you have an entire ordinance that's thrown out, and where I usually used to, you could enact a moratorium, that wouldn't work here, would it?
I think it might not. I would have to look, but I would be nervous.
And importantly, this thing at the bottom, the FCC has said the remedy for this, if the local government is not acted within 60 days, is the application will be deemed granted. And there's a process you have to go through. The applicant has to notify the local government, basically saying it's been 60 days, therefore we are moving forward as if it's deemed granted. Quite frankly, I have not seen this as a problem in Georgia, and I think part of it is because of the regulatory framework that we have in place here, that was put in place really through a cooperative effort involving the wireless industry. ACCG and Todd in particular were very active in this, as was Joe and a number of other local
and
governments. Van Stevens.
Shout out to Gwinnett.
Who I think is on the line, Van. Hope you're doing well.
I want to bring up one on that last slide if I'm under deemed granted. That's only so long as it falls within the definition of not substantially.
Correct.
Correct. I mean, that reading through it, it's easy to forget once you're immersed in all what we're actually focusing on.
Right. If it's an eligible facilities request that does not substantially change the dimensions, then
we're not talking about a new cell tower. We're not talking.
Correct.
Okay.
We're talking about a modification of an existing facility that does not go beyond those thresholds. But in Georgia, we've had it's actually been pretty busy last few years as we've worked, as I said, in a cooperative manner between the industry and local governments to address, in particular, co-location. That was the first press, and again, you go back to the reasons for co-location is to quickly meet the need, and we found that there were some ordinances in place that unnecessarily delayed the process of co-location. And I always like to compare co-location to adding a new tenant in an existing shopping center. You've already done the zoning gone through the zoning fight to zone and build the shopping center, and it really doesn't matter, aside from some building code issues, whether it's a Subway or a Quiznos or a Jimmy John's going into tenant space number 102. That's really a building permit issue. It's not a zoning. It's not a zoning issue unless, of course, it's a prohibited use in that shopping center. But so that the Broadband Co-location Act in 2010 established a streamlined procedure for permitting modifications and co-locations of wireless facilities. That was superseded this past legislative session, I guess 2 legislative sessions ago now, by the Mobile Build Act, which incorporates the same concepts of Broadband Co-location Act, but talks a little bit more about new wireless facilities as well as co-locations and modifications. Again, co-location is the same slide we saw before. Co-location is simply adding new antennas to an existing structure. So the Mobile Build Act, and you can see where it's codified there, keeps the limits on the scope of review for co-location. You cannot evaluate the technical, business, or service characteristics of the facility. You can't require radio frequency analysis like you might for a new tower, or other analysis related to the need or the business decision to co-locate. You really should process co-locations and modifications like any other building or electrical permit application. The Mobile Build Act, here it's a little, I should actually say FCC, I apologize, not FAA. It should say FCC, Declaratory ruling. I will take full credit for that error. But there's a little inconsistency between now the Spectrum Act and the FCC guidance on that. When this was written, the FCC guidance was the 90-30 day periods for co-location. Again, it's now 60 and 30 under federal law. And importantly, it now limits fees for co-location modification to $500. Again, because this is essentially like a building or electrical permit, it is not an opportunity to charge the local government or charge the industry $3,000 to $5,000 or $1,500 to do something that, quite frankly, your staff probably does in 30 minutes or less. It's not. There were very few local governments in Georgia who were charging a fee that was out of line with how much administrative time and administrative cost was involved in this, but it limits that fee to $500. The Mobile Build Act does place some limits on review of new towers. You can't put conditions on it that are conditions on approval that try to circumvent the Build Act. You cannot require the removal of an active tower as a condition of approval for a new tower, and you may not require tower placement on public property. Quite honestly, the industry would like to locate on public property if it makes sense. Typically, local governments exempt themselves from their own zoning ordinances, and so it's really a matter of getting a lease approved, but that location has to work. It has to work from a radio frequency standpoint. It has to fit into the system in order to be useful. And again, the Mobile Build Act adopts and I did it again, the FAA declaratory ruling. I don't know why I did that.
Well, you did that because we were talking about FAA approval of towers of those certain heights.
Yeah, but the shot clock, that should, again, read FCC declaratory ruling, and maybe I can fix that before we post it on the website.
A couple of questions. I just, again, reflecting what I hear from the county, may not require a tower placement on public property. Under any of these bills, is there a prohibition of local governments requiring that any new tower allow the local government to place its equipment on a private tower or antenna? I mean, I don't know if it's good practice.
I don't know that there's any prohibition. I know from my experience with my main carrier client, it's really their policy to allow that, allow the local government to place, typically it's E911 type communications on the tower as part of just being part of that community and trying to be a good neighbor and recognizing the importance of wireless communication to first responders. I don't think when you get into requiring that it be placed on that, you're running into a little.
The E word.
You're getting close to an exaction or a contract zoning that may be an issue. But my experience with my primary client has been that that's their policy anyway.
One more question, if I may, and we've dealt with this here in Metro Atlanta, particularly DeKalb County. Local governments can't really control zoning and land use as far as schools are concerned. Does this same rule apply if a school is in the negotiations to put up cell towers? How are your hands limited as a local government in determining whether or not to approve that application, Jeff?
I think it's generally conceded that for example, a school system, it's a separate local government. And there's you mentioned actually there's a DeKalb County case from years ago where there was a dispute between the city of Decatur and DeKalb County about zoning. I believe it was for the new courthouse over there.
Yep.
David, you remember that?
Yep.
And so there's some law on that, but generally I would say as a general matter, it's another local government. They control from the zoning standpoint and the land use standpoint what they do. Now building permits and things of that nature, there may be a difference there. So no, I don't think one government can really control the land use of the other as a general matter. There are some exceptions.
And I think the same would hold true of state property.
Yeah.
Though, there was a DeKalb case involving, I guess it was T-Mobile and DeKalb County recently. That case ultimately was dismissed on a more technical ground. It had nothing to do with really the merits of the case. But the judge basically said that the county school system had to, or T-Mobile through the county school system had to apply for the zoning approval and then get denied before they could timely bring forward the suit. So don't be fooled by the results of that case, because the results turned on something other than the merits that were being argued. Just very quickly, I know we're getting close to time, and we want to hear from Joe on his tips for local governments, but just some additional general provisions of the Build Act. You can't have zoning or permitting fees exceeding the reasonable cost of the actual regulatory activity performed. That's standing Georgia law, but it has been remarkable to me how a conditional use permit for the approval of a cell tower might cost $5,000, whereas a conditional use permit for the approval of a large regional shopping center might be $500. And
I would quickly caution any local governments who are tempted to do that to be very careful, because we do have circumstances where, not in the cell tower arena, but where that's happened in other cases where there have been subsequent class action lawsuits and they've actually been required to disgorge the extra money they made off of that back to the class. You don't want to do that.
Right.
You can get stuck with that, so don't do that.
And there's a federal case out of New York, I think the City of Mount Vernon case, where it did involve telecommunications fees, and ultimately some of those fees had to be disgorged by the consultant that was advising that local government. You can't have pass-through fees for contingency-based consultants, and then if you are leasing public property, you need to be mindful that it's not an opportunity to gouge the industry. It's an opportunity to charge fair market rate for lease of public property. That's pretty much it as far as Georgia law, and I'm going to hand things back to Joe to talk with you all as we wrap up here on some practice tips.
All right, I'm going to run through these pretty quickly, and much of this we've already touched on. You need to understand the increasing reliance upon this sector, and I think you're going to see that in citizens who come to speak for or against your cell towers. But you need to understand that it is definitely a growing trend. It's more than just a trend. You need to also understand, as a practical matter, particularly as the industry has matured, that these carriers, especially when we're not talking about spec towers, and as David mentioned, we don't see as many of those now. They've got a lot invested in their systems and a lot invested in designing their systems. And candidly, most of them really don't have an incentive to go build a tower that at least they don't think they need or are about to need. And I'm not saying there aren't exceptions, and you need to be wary of those, but generally, as a background matter, understand they don't really have an incentive to go build a tower that they don't think that they can use. You need to understand everything we've been over today about the legal environment. You need to monitor change the law, particularly regulations that the FCC comes out with, and also the one that I call, we talked about stealth towers. There was the stealth legislation, the one that was in the Jobs Creation Act or whatever it was. I missed that one initially myself years ago, and then David pointed it out to me. Also, you need to make sure that your standards are reasonably tailored to what you've got going on in your staff abilities. David and I talk about this a lot, and I think this may be one area where we may not agree. I know representing Cobb County when I was there, and it may have changed, we did not feel we had someone on staff who really was qualified to review radio frequency studies and things of that nature, so we did utilize an outside consultant. To my knowledge, most even large jurisdictions don't have someone like that on staff. So you need to make sure that your ordinance is written in a way that if you do want to or need to or choose to use one of these consultants, that you can use that person. You need to be careful how you use them. Their role, in my opinion, needs to be confined to the RF issues and maybe engineering issues, but you need to use your own staff if you have it, and I think many of you do. You need your own staff on zoning decisions themselves. You need to establish clear procedures, and you need to minimize delays. You know, I'll say it, maybe nobody else wants to. We all know that in the general zoning context, sometimes things get better if they cook a little bit. We've seen that in many cases. Maybe that might happen in cell tower cases, but I don't know that it does. And in cell tower cases, you have these shot clocks, so you need to be very careful about that. Try to work with the applicants. In my experience, most of the applicants are professional and cooperative in giving you the information that you need. I know there are some exceptions, but most of them are not difficult to deal with. Make sure that you're building your written record because you're going to need that if you decide to deny the application. Again, I'll say it one last time, explicitly reject any arguments that you hear either from your elected officials or from citizens that you're denying this based upon radio frequency environmental health effects. That's probably the single quickest way you can lose one of these cases that I know of. This goes along with what we already said. With your consultants, it would be my advice that you supplement your in-house staff skills to the extent that you need to, but I don't think you want them to take over your process.
And I agree with that, and I think some of you may have resources internally that you hadn't thought about. I would guess that many of you have a consultant that deals with you on communication needs for the county, communication needs for your first responders. They will often be willing to, as part of their contract or as a service to the community, to look at the RF information, and that's a resource that some local governments have in place that they're not aware of, that don't involve going outside the existing structure. As a planner, as a professional planner, these are in my mind, these are generally pretty simple land use decisions. We don't generate traffic. They don't generate smoke or noise. They use a very small amount of space. They don't generate any need for sewer or water service. So from a land use perspective, I think it's a pretty straightforward analysis. Using an RF consultant is something that's entirely up to you. I know local government planners that are very good at that, and it's really going to have to be tailored to your own needs.
Well, I would add to that, and it may not, in your opinion, generate a lot of those things, but it does generate a lot of angst. I mean, it's safe to say it was an elected county commissioner. When they're sitting in these hearings or making these decisions, I mean, we're trying to give them the tools to do it right legally, but I can tell you and Joe, maybe you could attest, it's one of the hotter issues that come up in front of a local governing authority.
Well, quickly, two big things when we had new attorneys come in the office. You will quickly find that zoning and land use decisions are your biggest decisions because there's so much politics involved.
Mm-hmm.
And people think, oh, that's boring. Well, it's not boring if you're somebody who lives in a subdivision next to some zoning application. That's when you'll have hundreds of people showing up to your meetings. You can vote to spend hundreds of millions of dollars, and if something everybody pretty much is okay with, you'll have nobody talk about it. But you can vote to allow a $100,000 structure or something, and you'll have 100 people. So, so it is important. I think also what you have to understand is therefore if you're one of these elected officials, it does affect you directly. I come about this sort of from a litigation, product liability, medical malpractice background. I did that and did local government stuff back in the 80s and 90s, and I guess because of that, maybe I just expect more from experts. I've seen so many bad experts that I want to have good ones that stand the test of time and stand the test of a federal judge. So that's why I feel that it is good to have those resources.
Yeah.
Ultimately, obviously, that's up to the local government.
Yeah, but if you're going to have outside resources, I think it's important that they be qualified. Like you say,
absolutely.
I recently had a situation where a person who was not a professional engineer was opining as to the sufficiency of engineering calculations that were prepared and stamped and sealed by a professional engineer, and that was, quite frankly, a very frustrating situation. And ultimately, we worked through that. But make sure if you're hiring somebody to do engineering analysis, that they have the proper qualifications and can demonstrate those for you, because otherwise you're putting yourself at risk.
Well, and that leads me into very quickly, because I know we're about out of time. I guess if there's one word I wanted to say to our local governments, credibility is key here, and that dovetails with what David just said. If you're going to have a consultant or an expert, it needs to be someone who knows what they're doing and has the proper professional credentials, because you need to assume that a U.S. District Judge is going to read that. Remember that a U.S. District Judge has a lifetime appointment. They don't have to face the voters in your jurisdiction. And so you're only going to get one shot at doing this. Do it right. Make your decisions in writing. I know it's hard given what we have now with the Supreme Court precedent, but my suggestion with you, in my perfect world, what I would tell you to do is go ahead, take these applications in, act on them quickly from a staff standpoint, do it quickly enough that you're in a position where, and not everybody agrees with me, but this is how I would do it, you can hear the case, your Planning Commission and your Board of Commissioners can hear the case, have an open public hearing, hear what you need, ask the questions you need from the experts, from the applicant. And then I would suggest that you close the record at that point, and then after you've got all the evidence in the record, you then have an attorney prepare a proposed decision. If you have any inkling that you think that there's going to be a denial or a severe curtailment of what they've asked for, I would suggest that you have an attorney prepare a decision based on the record that would allow you to do that. And then you come back and vote at a later meeting, bearing in mind all these deadlines that you have. That's not ideal, but I think that's the best scenario. What we used to do prior to that decision was, if it was a case, in some cases you just know without even hearing it, it's not going to be a problem. It's maybe an industrial area, there's nobody who's going to complain, you know they need the tower. But if there's any inkling that it could be a problem, we would hear the case, the board would hear all the evidence, the board would make its decision, but then it would direct the county attorney's office to come back with a written decision basically summarizing all that at the next meeting. I don't think you can do that anymore. And so my suggestion would be to have the hearing, have the record open for the hearing, close the record at that point, and then work on a decision to be voted on later. That's not perfect, but that's the best solution that I have.
Closing comments?
Well, just a closing comment from the industry perspective. We're trying to serve your constituents, and every day more and more of your constituents rely on these wireless devices in their personal lives, their business lives, for emergency communication. I have worked many hours with many local governments in helping prepare ordinances that work not just for the local government but for the industry as well. It should not be an adversarial situation. I think we've proven that through our work with ACCG and Joe and Van and others, that the industry recognizes the importance of these decisions and the emotion that's also surrounding some of these decisions. But we're also trying to serve your constituents, and I think right now 45% of all the households generally in your community rely on these devices, and that trend line is only going to go up as we move forward, and the industry stands ready to work with the local governments in Georgia to make it work for everybody.
And this is Todd again, and I also want to commend both Joe and David. Joe and I have worked together for many years, and to be honest with you, this issue can get quite contentious at the General Assembly, and not all carriers. Well, let me just put it this way: it's been a pleasure working with Verizon and you, David, on trying to find the compromises in the middle ground when a lot of these issues have come up. There's a lot longer to go, but I think what we're seeing now, and Joe, we just commented, it doesn't really matter how we address it here in Georgia. The FCC has come out with a lot of these judgments in the past, twice in the past 6 years, that have substantially changed what we're dealing with, and what is now law that local governments must go by. I had a couple of questions that have come up. And we mentioned earlier, I mean, if I was looking at this, and I do, as a county commissioner and representing them, our hands seem to be significantly tied, certainly on prohibiting or denying facilities, cell towers going into communities. So my next question, and if either one of you feel free to answer, is how do we work together with the wireless industry? If we can't deny them, I mean, can we at least do something constructive to direct them to the least contentious location?
Let me say this, and I can see how coming away from this presentation, you might say, okay, we can never deny one of these again. I want to make sure I'm clear. There are going to be some that you probably are going to want to deny, and maybe should be denied. But what I want to emphasize is that it's getting harder and harder to do that. The easy sites are gone. It's the hard sites now.
And that's
going to be harder, and that's residential. I know in Cobb, for example, we have, and I think Gwinnett's the same way, we have vast swaths of residential property.
Same thing in DeKalb County.
Same thing in DeKalb. And that's where the rubber's going to meet the road. And having said that, it may be that the federal legislation and the FCC regulations that have come out candidly are going to force local governments and the industry to cooperate more. I want to echo what Todd has said. David has always been very professional and very good to work with. We don't always agree on everything, but when David tells me something, I know that it's true. And his client has been a good client for us to work with. So all I can say is maybe more things like this, more dialogue would be helpful. But I guess what I do want to say is I want to make sure that nobody comes away from this. I would never say that you can never deny a cell tower application. I know David would like for us to grant them all, but there are going to be times when you have to. But I think you're going to have to be a lot more discreet and careful with it.
And I think it's incumbent on the industry to find as good a site as possible to meet their needs. And sometimes that's in an area where it is going to cause angst in the community. But again, we are required to provide the service. We're demanded by the customers who are your constituents to provide the service. And the burden, a lot of burden is on us as the industry to find sites that offer the best compromise. Sometimes there's, as Joe said, the perfect sites are few and far between, but there's still some good sites there, and there's some sites that if the industry and local government works together to put in place, whether it's some sort of stealth treatment or other things that can work, then we're typically willing to do that.
This is kind of going back a little ways, but when we have these hearings, either at the local level or General Assembly, we'll have folks coming in arguing that a tower isn't needed because they'll show you their cell phone and they have 5 bars. I mean, the only reason I bring this up is because if you haven't dealt with one of these cases in your county, you're going to. What would your response to that be? I mean, I don't need it. Here's my Verizon. I've got 5 bars,
well,
and we're arguing you need a
I used to
tower
win
thing.
cases based on that. I say used to. It's harder to win cases.
Yeah, I mean that. First of all, that's not evidence. That's an anecdotal situation. And yes, you could have 3 or 4, potentially even 5 bars on your phone. But does that mean that you've got acceptable data speeds, acceptable capacity, those sorts of things? Can you access the network? Maybe, is that a high demand time that you had the 5 bars, or is that in the middle of the night when no one's using the facility? So I would caution anybody against using that as a basis for denial, because first, it's anecdotal. Second of all, it does not reflect the true need that the carrier is trying to meet. And to go back to something Joe said, the industry is not interested in spending hundreds of thousands, potentially millions of dollars on facilities they don't need. They've got enough real needs out there. They don't need to spend money on things that are needless.
The other question, we touched over it briefly. When we started this, I don't know, maybe 18 years ago, the biggest concern, one of them I had from the counties was maybe third parties coming in and building speculative towers. Go through the process. There was concern that these towers would go in, wouldn't have a client, they're stuck, and meanwhile, y'all realized your best, location could be somewhere else, and they're stuck with a lot of towers with very little facilities or infrastructure on them. What's the trend as far as speculative tower or third-party speculative towers, or at least from your two's perspective?
We had some of those in Cobb. I have not seen one recently. I don't know about other places in the state.
Well, two things. One, I think I mentioned earlier that true speculative towers are very rare these days. Typically, what the industry has, as it's matured, has evolved more toward build-to-suit, where you would have a company that builds towers, building a tower for Verizon or one of the other carriers at the direction of Verizon in a specific area to serve the need that the carrier has identified. So I think that from an industry perspective, the sort of wildcat, Wild West speculative tower days, they may not be gone entirely, but they're certainly on the way out. From the local government perspective, I think having a provision in your ordinance that requires the removal of towers when they are abandoned and defining what abandoned means, I think is perfectly reasonable and prudent to protect against the possibility that a true speculative tower were to come into your community.
And we've been over earlier, just to make clarification, Georgia law does not allow a local government to condition the approval of a new tower application on the removal of an existing one. However, we are able to work on having forced the removal of an abandoned tower.
Sure.
The language, we were very careful in compromising on that language several years ago.
Yeah. Just like you can force ultimately the demolition of a dangerous structure or something like that. It's clearly within your power.
As a practical matter, though, for those of you in the counties that think that we're up here with our heads in the clouds, I know that sometimes that can be difficult. I did a lot of the nuisance abatement stuff that we did for years, and you've got to have the money to do it. So luckily, though, with these abandoned towers, hopefully you're going to have some sort of corporate wherewithal behind it where you can get that paid for by the company. But that may depend, especially if it was a spec tower or something like that.
I'm looking through the questions. The only one we had on there, or the additional one, dealt with how to get funding to help upgrade the 911 system or E911 system. these two gentlemen, that's not part of today's discussion, but I did want to recommend the individual that asked the question to please call Deborah Nesbitt here on our staff at ACCG, and she could put you in contact with the right individuals. I'm going to ask one more time, do we have any additional questions? Ladies and gentlemen, it's been a pleasure hosting today's webinar at ACCG. I hope you found it useful and informative. I want to personally thank both David and Joseph for joining us today. Again, I've worked with them for many years. They know the subject well. They're easy to work with, and I think you've heard from some of the brightest, the best and brightest of the experts in the state. Again, I will repeat, tomorrow morning we will post the webinar and the PowerPoint presentation on our website, so you could show it to friends and family alike at any time with easy web access. That's what we do, advancing Georgia counties. It's been a pleasure, and thank you all for joining us.